Hello everyone, welcome back to Legally Dephine. In this video, we are moving on to part B of our lecture on court processes, and we are going to look at the action procedure, what it is and the stages followed in an action procedure. If you haven't subscribed to Legally Dephine yet, please click on the subscribe button down there, like and share the video with all your friends. Let's get into it. There are two ways of instituting proceedings in civil courts: action procedure and application procedure. The law may specify in a given situation which procedure is applicable, and where there is no specific direction given by law, the choice between the two procedures depends on whether or not there are material disputes of facts. The action procedure must be followed whenever there are material disputes of facts. This procedure involves the court in making a finding of fact between two versions of facts. The parties in an action procedure are referred to as the plaintiff and defendant. The plaintiff is the party who institutes and drives the case in the courts, whilst the defendant is the party that responds or denies liability as set out in the summons instituting the claim. There are differences in the action procedure of the Magistrates Court and the High Court. Let's start with the action procedure of the Magistrates Court. The action procedure in the Magistrates Court is governed by the Magistrates Court civil rules. Let's go through the stages of the action procedure in the Magistrates Court. Action procedure in the Magistrates Court is commenced by the issue of summons. A summons calls upon the defendant to answer the plaintiff's claim within a specified period of time. The time within which the defendant is supposed to answer the plaintiff's claim is called the dies injustitiae. In a magistrate's court, the summons must also contain a particulars of claim, setting out the cause of action. Before a summons is served, it must be issued by the court, meaning it must be signed and stamped by the clerk of court. In a magistrate's court, the summons are served by the messenger of court. Summons are provided for on Order 8 Rule 1 of the Magistrates Court Civil Rules 2019 as follows. The process of the court for commencing an action shall be by summons, calling upon the defendant to enter an appearance within a stated time after service to answer the claim of the plaintiff, and warning the defendant of the consequences of failure to do so. The period referred to in Sub-Rule 1A, within which the defendant is called upon to enter an appearance, shall be not less than 7 days if the defendant does not reside, 14 days if the defendant does not reside within the jurisdiction of the court from which the summons is issued. The summons shall be issued by the clerk of the court and shall bear the date of issue. The original of the summons shall at all times be retained of record in the office of the clerk of the court. The particulars of claim shall appear on the face of the summons and shall be signed by any such person as is mentioned in Order 4. The summons shall give, subject to Sub-Rule 3, an address for service which shall be within a radius of 15 kilometers of the courthouse from which it is to be issued, and the postal address of the plaintiff, and the facsimile or electronic mail address, if available, of the plaintiff or such other person as is mentioned in Order 4 who signed the summons. Where there are fewer than 3 legal practitioners practicing independently of one another within 15 kilometers from the courthouse from which the summons is to be issued, the address for service may be one which is further than 15 kilometers from the courthouse. The particulars of claim shall show the nature and amount of the claim, and the rate of interest and the amount thereof claimed up to the date of the summons, and whether or not costs will be claimed if the action is undefended, and any abandonment of part of the claim and any set-off. The messenger shall endorse the amount of his or her charges for service thereof on the summons. Where the summons contains more than one claim, the particulars of each claim and the relief sought in respect of each claim shall be stated separately. Where the particulars contain more than 100 words, they may be contained in an annexure served with the summons, which annexure shall be taken to be part of the summons. The clerk of court may refuse to issue a summons in which an excessive amount is claimed for legal practitioners' costs or court fees. Okay, so I know the provisions in our Magistrates Court Civil Rules which are explaining the stages of our action procedure are very long, but don't worry, bear with me, we shall understand everything very soon. Alright guys, to make everything clear, let's bring this to life. We are going to use a sample case with some new fictional friends from Legally Dephine. Please pay attention because we are going to see how real court documents look like using their story. Take note that any similarities of names with our fictional characters is purely by coincidence. And if you haven't subscribed, make sure to click the subscribe button. On 5 March 2025, George Ziwa borrowed $5,000 from Silas Mtadi, money that Ziwa promised to pay back after a month. 1 month later, on the 5th of May 2025, Mtadi asked Ziwa for the money and he promised to pay after 1 week. A week passed and Ziwa did not show any efforts to pay back the money despite several demands from Mtadi. The tension between them escalated to the extent that Ziwa blatantly refused to pay back the money. Having failed to get his money back from Ziwa, Mtadi decided to take him to court. Now, let's use our sample case to see how the summons which were served on George Ziwa looked like. If you missed any part on the case, make sure to quickly rewind so that you catch on and we move on together. This is how the summons which were served on George Ziwa looked like in their entirety. The summons are found in the Magistrate Court Civil Rules on Form CIV4. If you look at your far top right corner, it's written Form CIV4. That's the number of the form in the Magistrate Court Civil Rules. Take note that all the text you see in black ink is how the form looks like in the Magistrates Court Civil Rules. It comes like that by default. And the red part is the part where the legal practitioners for Silas Mtadi filled in. On the top left corner under the heading Summons Commencing Action, there is a part which is written Issued by. This is the section which is used by the clerk of court to issue the summons. So the clerk will sign there and stamp the summons. Under the section which is used by the clerk of court, there is a section where there is bold letters. That section is where you will find the province where the magistrate's court is located, the name of the plaintiff and the defendant and their addresses. Now we move on to the particulars of claim. As we have mentioned that the summons must also contain a particulars of claim which sets out the cause of action. This is the part which is very important. As I have mentioned earlier that you have to pay attention to the story because this part is where they put key details of what exactly happened and the particular dates on where the events happened. For example, paragraph number 1 is where the money which was owed to Mtadi by Ziwa is indicated and the key dates on which the money was lent and where the money was supposed to be paid. It is very important to take note that for this particular summon, the particulars of claim are part of the summon because they are below 100 words. If the particulars exceed 100 words, they must be contained in an annexure attached to the summons. An annexure means a separate document, so the particulars of claim will appear on a separate document which is then attached to the summons if they exceed 100 words. Just underneath the particulars of claim, there's a section where there's a prominent $sign. That is the section where all the charges associated with the serving of the summons are attached, including the legal practitioner's charges, the court fees, the messenger's fees, and so on. At the very end of our summon, there's a section which is typed in bold. That section pretty much encompasses the addresses of the plaintiff and the defendant and their legal practitioners. So that's pretty much it for the summons in the Magistrates Court. If you need us to do a more detailed video on the summons themselves, let us know in the comment section. Where the defendant wishes to defend the action, he or she should enter an appearance to defend. This must be in form of a written statement filed with the court. Where the defendant does not wish to defend the action, he or she may consent to judgment. Where the defendant fails to enter an appearance to defend altogether, the plaintiff may obtain what is called a default judgment. Where the plaintiff is convinced that the defendant has no bona fide defense to the claim but has entered an appearance to defend only to buy time, the plaintiff may apply to the court for what is called a summary judgment. Appearance to defend is provided for on Order 10 of the Magistrates Court Civil Rules as follows. A defendant wishing to defend action shall, within 7 days after service of the summons, if he or she resides within the jurisdiction of the court from which the summons was issued, 14 days after service of the summons, if he or she does not reside within the jurisdiction of the court from which the summons was issued, or within the period limited by the summons, whichever is the longer, enter an appearance to defend by deliver of a memorandum in writing that he or she intends to defend. The clerk of court must record every entry of an appearance to defend in an appearance book. In reference to our sample case, Ziwa was served with summons by Mutadi and Ziwa decided to enter appearance to defend. This is how Ziwa's appearance to defend looked like. After the clerk of court issued the summons, the case was assigned with a case number which is appearing on the top right corner of the appearance to defend. The rest of the details are pretty much similar to what was shown on the summons. After entering an appearance to defend, the defendant may request further particulars from the plaintiff in order to enable him or her to plead or to answer the plaintiff's claim. Further particulars for the purposes of pleading are provided on Order 12 of the Magistrates Court Civil Rules as follows. A defendant, whether in the main claim or counterclaim, may at any time after service of summons or counterclaim and before delivery of the plea, apply to the plaintiff by notice for copies of all or any of the accounts or documents upon which the claim is founded, and such copies shall be furnished to him or her by the plaintiff within 7 days after receipt of such notice. The plaintiff shall on notice forthwith allow the defendant to inspect the originals of such accounts or documents. Any part may, by notice delivered not more than 7 days after entry of appearance in the case of a summons or the delivery of any other pleading or judgment on any exception to such pleading has been given, require the party delivering such pleading to deliver such further information as is reasonably necessary to enable such party to plead. The party delivering such pleading shall within 7 days after receipt of such notice deliver the information reasonably required. Referring to our sample case, Ziwa requested further particulars from Mutadi as shown on the document. So Ziwa was requesting further information from Mutadi, which are the further particulars, which is the information he was going to use in his plea. For example, if we look at paragraph 1, the defendant was requesting for a contract as proof that the plaintiff lent him money. This is the defendant's answer to the plaintiff's claim. It must be filed with the court and served on the plaintiff. The plea must be filed within the time specified in the rules of the court. And in addition to the plea, the defendant may also make a counterclaim, that is, making a claim against the plaintiff. The plea is provided for on Order 16 of the Magistrate Court Civil Rules as follows. The defendant shall, within 7 days after entry of appearance or delivery of documents or particulars in terms of Rule 1 or 2 of Order 12, further particulars, or if application for summary judgment is made, the dismissal of such application, or the making of an order giving leave to defend, or if exception, motion to strike out or special plea is set down for hearing in terms of Rule 1 of Order 14. Exceptions, motions to strike out and special pleas. The dismissal of such exception, motion or special or any amendment of the summons allowed by the court at the hearing of such exception, motion or special plea. Deliver a statement in writing to be called a plea. Provided that if an appeal is noted against a decision on an exception or special plea, or such proceedings are brought on review, the plea shall be delivered within such time as is directed by the Court of Appeal or on application by the court. The plea shall be dated and signed by any such person as is mentioned in Order 4, representation of the parties. The defendant in his or her plea shall admit or deny or state that he or she has no knowledge of or confess and avoid every material fact alleged in the particulars to the summons, and clearly and concisely state the nature of his or her defense and all the material facts on which it is based. For the purpose of this order, information delivered by the defendant in terms of Order 12, further particulars, shall be deemed to be included in the plea. This is the defendant's plea, and with reference to our sample case, the defendant, who is Mr. George Ziwa, was denying that he owed the plaintiff a sum of $5,000 as he claimed. The defendant also argued that he paid back the money on 20 May 2025 at 4:00 p.m. at his place of residence, and two people, Gamumuti and John Sheren, saw the defendant give plaintiff the money on the 20th of May 2025. The plaintiff may require the defendant to furnish further particulars in order to enable him or her to reply or to prepare for trial. This is in terms of Order 12, Rule number 3 of the Magistrate Court Civil Rules. Order 12, Rule 3 provides, any party may, by notice delivered after the pleadings are closed, require the other party to deliver such further information in respect of any pleading as is reasonably necessary to enable that party to prepare for trial. The party receiving such notice shall within 5 days deliver the information reasonably required. This is the plaintiff's reply to the defendant's plea. This is usually necessary where the defendant makes certain allegations in the plea which requires a reply. Reply is provided for on Order 17, Rule 1 of the Magistrate Court Civil Rules as follows. Where the defense is other than a bare denial of one or more of the allegations of the summons, the plaintiff may, within 7 days after the delivery of the plea or after the delivery in terms of Rule 2 of Order 12, further particulars, or further information in respect of the plea, deliver a statement in writing to be called a reply. All the above documents from the summons to the reply or the replication are technically called pleadings. Pleadings are deemed closed if the parties join the issue, that is, if they make it clear that they are in disagreement and they look to a trial for a resolution of the dispute. Clause of pleadings are in terms of Order 17, Rule 4 of the Magistrate Court Civil Rules. They provide, upon the delivery of a reply or where no reply is delivered, upon the expiration of the period limited for reply, the pleadings shall be deemed to be closed. After the close of pleadings, either party may apply for discovery or discovery of documents, that is, requiring the other party to specify the documents and books that they are going to use at the trial. The books and documents which are not disclosed may not be used at the trial by the party which failed to disclose them. Order 18 of the Magistrates Court Civil Rules provides for the discovery and inspection of documents as follows. After the close of pleadings, either party may, before the holding of a pre-trial conference, deliver a notice to the other party calling on him or her to deliver a schedule specifying the books and documents in his or her possession or under his or her control relating to the action which he or she intends to use in the action or which tend to prove or disprove either party's case. The schedule shall be delivered by the party thereto required within 7 days of the delivery of the said notice. If privilege is claimed for any of the documents scheduled, such documents shall be separately listed on the schedule and the ground on which privilege is claimed in respect of each shall be set out. A book or document not disclosed in terms of this rule may not be used for any purpose in the trial of the action by the party in whose possession or under whose control it is without the leave of the court on such terms as to adjournment and costs as may be just, but the other party may call for and use such book or document in the cross-examination of a witness. After the discovery of documents, a pre-trial conference is held. The pre-trial conference is attended by both parties and it is chaired by the magistrate. The purpose of a pre-trial conference is to define issues and reach agreement where it is possible, for example, on the length of the trial, the number of witnesses, and exhibits. Another purpose of the pre-trial conference is to try and explore the possibility of settling the matter without going to trial. This is in terms of Order 19 of the Magistrate Court Civil Rules. Order 19 provides as follows. After the close of pleadings and the making of discovery by both parties, a party who wishes to have the action brought to trial shall request the other party to attend a pre-trial conference at a mutually convenient time and place. At the pre-trial conference, the parties shall attempt to reach agreement on possible ways of expediting or curtailing the duration of the trial, and in particular as to all or any of the following matters: the obtaining of admissions of fact and of documents, the holding of any inspection or examination, the exchange of reports of experts, the examination of discovered documents, the giving of any further particulars reasonably required for the purposes of trial, the plans, diagrams, photographs, models, and the like to be used at the trial, the consolidation of trials, the quantum of damages, the definition of the real issues and the manner in which any particular issue may be proved, an estimation of the probable duration of the trial, the preparation of correspondence and other documents to be handed in at the trial in the form of a paged bundle with copies for the court and all parties. And if it is practicable to do so, the parties shall attempt to reach a settlement of all or any of the matters in dispute between them. The pre-trial conference is provided for on Order 19 from Rule number 1 up to Rule number 11. You can read the rest of the rules on your own. In the Magistrates Court, the date for the trial is obtained from the Clerk of Court. After getting the date, the party who obtained it must file and serve a notice of set down. Set down for trial is provided for on Order 19 Rule 2 of the Magistrate Court Civil Rules as follows. The trial of an action shall be subject to the delivery by the plaintiff after the pre-trial conference has been held of notice of trial for a day approved by the Clerk of Court, and if the plaintiff does not, within 14 days after the pre-trial conference, deliver notice of trial, the defendant may do so. The deliverer of a notice of trial shall ipso facto operate to set down for trial at the same time any counterclaim made by the defendant. Service of a notice of trial, including notice for reinstatement where the trial has been adjourned or postponed sine die, shall be effected at least 7 days before the day approved by the clerk of the court. This is the notice of set down from our sample case. The matter was set down for trial on the 30th of June 2025 at 11:30 a.m. The important point to note here is that the burden of proof is on the plaintiff. So in order to succeed, the plaintiff must prove his or her case on the balance of probabilities. The court will finally give a judgment at the end of the trial. A judgment may take one of the following 3 forms: either judgment for the plaintiff, judgment for the defendant, or absolution from the instance. Absolution from the instance means that neither party won the case and the parties remain at the position they were before the trial started. So that's pretty much it for the action procedure for the Magistrates Court. It really took an arm and a leg to prepare some of the documents, the sample cases we have used for the purposes of this video. So guys, let's get this video to 1000 likes and see you on the next video.